Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney client relationship. This communication may constitute attorney advertising. Welcome to AI Council Code. The AI Council Code is here to keep you up to date on all AI legal issues arising in the modern business frontier. I'm your host, Maggie Welsh, and today Steve Mann, a partner in our Dallas office, has joined us today. Hi, Steve. Thanks for being on.
Good to be here.
So, one of the most interesting parts of my job, and maybe yours as well, over the last few years, has been talking with clients about best, best practices for using AI at their companies and really learning about how companies are using AI. And I know that you and I have had several conversations with clients about just that. So, today I'm hoping that we can talk about some of the hot questions that we're getting from clients related to AI vendors and AI contracts and how attorneys can be thinking about the AI that they're using within their company.
Happy to talk about it.
So, to start off, why don't you introduce yourself and tell everyone a little bit about your background and your work with AI?
I'm a partner in our Dallas and Austin offices, and my practice mostly involves emerging and novel technology. AI fits pretty squarely into that these days. I was a software developer for about 10 years before I became a lawyer. These kinds of things fit in my wheelhouse a bit. So I get questions around AI quite a bit these days.
When we talk about I think it's hard to talk about AI without talking about data. Data is king and it's important for companies, but also necessary for running some of these AI models. So, when a company wants to engage in a contract involving a counterparty that might be receiving that company's data or confidential information, what are some ways that in house counsel can think about addressing the possible use of AI tool that counterparty might be using?
This is a good question. And before I answer it, let me agree with you on the value of data, especially in contexts these days where you have manufacturers of sophisticated equipment that is highly instrumented and generates significant amounts of data through usage, and then the actual customers that buy it and put it into use. There's a tremendous disparity in the equipment that generates all this data and the usage that you see from it on a day-to-day basis. And while I think most companies have long treated their data as a valuable asset, I think that that value is only growing. I've had clients that essentially agree to give counterparties the rights to use data and to do various analytics with the data in a form of currency, where the data was of such value that it became a chip on the table as for purposes of the deal, that the notion of data use and analytics rights was not an ancillary deal issue, but being a fundamental financial lever as it related to the deal, where scope of data rights played against the underlying economics of whatever the deal might be. So when we say that the data has value, it has actual value, dollars and cents value, and people should look at it that way because there's tremendous value in insights that other parties can make use of, whether they do it with AI tools or not. But with that said, a lot of these questions these days focus around the use of AI, but I think that's really coming at it from the wrong angle, the tail wagging the dog, in that the usage by the counterparty of your data is more of a how they're doing it and probably less of what they're doing. Set aside the AI part. For the longest time, you'd see in any NDA for exploratory discussions that a party is providing data to the other for a permitted purpose, for some enumerated and specific right of what they can do with it. I imagine that most lawyers who might be listening to a podcast like this have probably seen ones that are, we'll just say, not narrowly tailored. I've seen NDAs and other agreements that say things like the permitted purpose is exploring mutually beneficial business opportunities. I don't know what that means. That's been a problem before AI was a thing. But the potential uses of highly advanced analytics tools really just puts a focus on something that there should be probably more focus on than there was previously. And that's having a properly, narrowly tailored, specific scope of what the other party can do with the information you provide. So that again doesn't have anything to do with AI. It just is a good reminder to go back and revisit something that I think we've all known generally, which is the more narrowly and specifically tailored that that permitted use can be, the better. Once that's nailed down, then you can pivot to how they can do that. And so at that point in time, I mean, there's lots of ways to address it. Most of these don't speak to specific methods on how a party can process data. We don't talk about whether they can use Outlook or not, or whether they can use other tools or not. But when you have these tools that can do advanced analytics, perhaps it's a good idea to put some guardrails on the tools that can be used. For example, when you look at the normal kinds of restrictions these types of agreements would normally include, they tend to say things like you can't share the data with third parties unless that third party has a need to know, and they're subject to limitations that are consistent with those in this agreement. That type of restriction works equally well with AI tools. There seems to be a focus at times on people wanting to craft these highly parsed, very specific restrictions and limitations geared towards preventing usage of AI tools. I tend to caution against that because provisions that are that specific and detailed tend to be things that just give a roadmap on how you can engineer around them. Somebody wants to do something without violating the restriction. The premise that we're trying to protect is not specific to AI as much as it is protections against improper usage of data. As these tools emerge and the use of these tools by third parties emerges, you're seeing a divergence in the types of use cases and deals that come up relating to AI. One are the very specific ones. Party A, Party B want to get together and do some type of a collaboration or development effort that is very specific about looking at a very confidential, highly technical data set and applying a very specific set of tools to see what they can develop using it. It is a focused effort. Then the other is everything else, right? Your traditional M&A data sharing diligence effort. Who knows what tools the other side's going to use, and we want to protect against unintended uses. So most of what I'm describing here relates to that second category. Like, what should people do to protect against this ancillary usage of AI? And my answer is to have properly structured, narrowly tailored permitted uses, then rely on that to provide the levers you can use to enforce those rights against a third party. And these very specific instances where it's a highly confidential data set that's being shared for a very particular scope of use, then that's going to have to get dealt with directly. And just an agreement that is literally nothing else but these restrictions and requirements as it relates to this particular solution. And these are very divergent paths on the way that you could contract these two things.
Thanks. That's helpful to think about in terms of the two paths and how companies can protect their data in terms of thinking about the world that's out there of companies, how they might be using AI and making sure that it's not, when we talk about confidential data and sharing confidential data, sometimes in agreements we have the language as to use the same precautions that you would keep your own confidential data,
Yeah.
right? And so there it does raise the issue of what is the other company doing with their confidential data and really knowing about, I guess, knowing what questions to ask about how they might be using your data.
So I would say that those types of provisions usually relate to how you want the other side to protect the data that you've provided during the pendency of whatever this thing is. It's not that tends to be a kind of parallel to what are they allowed to do with it, right? And I feel like a lot of the risks that people are particularly concerned about in this space are I'm going to give them this data and then they're going to go train models with it. The AI is going to regurgitate it to something else. And I think those can be hit head on with narrowing the particular specific permitted purpose. Understanding that there's a reason why some of these have evolved to be permitted purposes, like exploring mutually beneficial opportunities. Because if you have a very narrowly tailored one, that means anytime it changes, you have to go back and change the agreement. But that's the way you will have to protect data in these evolving times where the data has increasing value and expanding potential space of use.
So we talked about data and ways companies might be able to protect their data as it relates to going into the AI model. Now I want to talk about the outputs of the AI model. When companies are looking at vendors or even business partners that contemplate the use of AI technology, what are some best practices that attorneys can do to address the ownership of the AI generated outputs? By outputs, I mean both the responses that the AI model might create and the prompts that you put into the model and what that might generate, and the results of the model training and some of the iterative updates on the model that might be present from the company.
So, to answer this in a roundabout way, I think when we're talking about trying to cover this stuff in contracts between two parties, legal coverage on these, you have to look at the pure wrinkle presented by some of these AI tools and just these other tools where the thing that the tool does is not discernible in a kind of traditional legal causation path, right? Where you can't look at data in analytics step one, analytics step two, analytics step three, result, right? Where you can have a good scholarly proximate cause analysis that showed that this thing resulted from that thing. These are, if you looked at it as a plot process flow chart, the AI models in many cases would be a black box that I use a bit snarkily to say something went in, there's a black box, a result comes out. When I used to write software, we call those AMO boxes. There's a box where a miracle occurs and then the outcome comes out. Since the causation chain isn't as direct as we would normally like, the first step in trying to protect against these kinds of things and what the outputs might be and who might own the right things is to actually do diligence on the upfront. So in kind of the cautionary note I mentioned before, when you know going into a potential arrangement that the data that you're going to provide to a third party is going to be fed through some AI tool and people are going to do things with it, you have to start with getting into the weeds of exactly what that is. What foundational model will be used? One of the open source ones, something available from a third party. Where will it be hosted? Is it dedicated to this particular arrangement, or is it something more general? Is it a pre-trained model, or is the focus to potentially train a new model? What will the other side or anyone else be permitted to use that resulting model for? And these become important because if what we're talking about is trying to establish a framework and a contract that governs this, really what we're talking about is trying to establish restrictions where you can actually prove they were breached. And so it's very difficult to set up a construct that says you can't use this data, you can't analyze this data in a way that produces a derivative work, because it's so early in this to understand what the framework would be in proving that chain of causation as to whether something was derivative. But you can prove whether the data that party A provided to party B was then fed into this model, and whether personnel at party B logged into that model and did stuff with it that was outside the contractual scope. I think it's important to keep in mind crafting the contract provisions around these that have provable compliance or provable breach, as opposed to some of these more esoteric concepts around whether some resulting development was derivative of the data that was put in the front end. Those are black holes as far as trying to actually reach a result. Whereas if you can craft restrictions that the litigators have a chance of showing breach, then you have a contract that you can assert. So there's also some measure of realism that I think people have to have, which ties to the diligence, right? If there's an arrangement parties are entering into. And the intent is that it's going to be based on a foundation model that's provided by the other side. It's a third party model. You could put restrictions in the contract between you and the counterparty about who owns outputs, but those are probably not going to line up with the contract from the third party or the terms from the AI provider. And so it's important to understand what data you're going to provide, the risks that are presented by that data, and then the reality of what's going to happen to it once you provide it, and then build a contract around those circumstances. These are not things that boilerplate forms tend to work well for, because the absolute type restrictions that you see in those tend to not align with the reality of what happens.
I think that's an excellent point about really figuring out what sort of triaging about what
Yeah.
are the real issues here and what can you do to put yourself in the best position going forward if you do need to enforce this, what you might need to hang your hat on.
Yep. I've had clients that look, there's a lot of interest in this space and in taking some of these highly complex data and seeing the things that can happen with it. Here would be a good example. I have clients that have large data sets that result from processing techniques that they use that involve trade secrets. And that there's never been a huge concern that if you provide that data to human third parties, that somehow the trade secrets that were used in generating that data would somehow really be discernible from just looking at the data itself. That risk profile changes with some of the capabilities that we're seeing in some of these emerging tools. And my folks have considered what they can do with some of these third parties that are providing tools like this. And it's not something that at the end of the day you can necessarily solve by contract. I don't think we know right now whether if you provided a data set like that and an advanced model were to purposefully or not essentially reverse engineer the trade secret that's in that, whether or not that would invalidate trade secret protection for the trade secrets that were used to generate the data in the first place. I think it will be a long time before we really know that with some certainty. And so the diligence part up front has to take into account the sensitivity of whatever IP you're trying to protect that's embodied in the data and what the other side is going to do with it, and where it will be. Like I've had instances where my folks wanted to do some analytics using AI tools with some very sensitive data. And the way that they got comfortable doing it was by implementing the AI model on IT hardware in the customer's data center, doing it locally, where we're all doing it together. It's not on a third party's SaaS platform, it's here. We also had contractual protections, but the primary protection around trade secret leakage is that it's happening on our own gear and our own data center, and we control what gets out. With that, you can have contractual protections that also allocate ownership, but those are the suspenders to the belt in that scenario. It's the implementation of the partnership that provides the protection. This has to be a combination of practical diligence around what's being envisioned, how it gets implemented in an actual technical level, and then contractual provisions that tie to that.
And I assume it depends on the party when the partner, like you're talking about in the different relationships, but how amenable are third party AI providers or AI partners in coming up with these creative solutions or in negotiating contracts? Is it a back and forth? Are they open to negotiating some of these terms and conditions, or is it really a one-way street right now?
In my experience, they've been pretty open to it. There's two groups: the counterparties that are themselves the AI platform providers. They're very interested in data sets and in trying to find unique applications of their tools in ways that advance the tool itself. And then there was the other group where you might have, kind of in my example from earlier, you have manufacturers, big complicated machines that are highly instrumented. And then you have their customers buy hundreds of them and operate them. Both of those groups are kind of interested in the things that you could learn from doing those types of analytics. And so in the second group, there's been tremendous flexibility because sometimes the permitted purpose or the stated intent of those parties is really nothing more than take all this data and the knowledge that the engineering folks have, put it through some of these tools and see what pops out, for lack of a more technical description. And so finding a way to do that in a way that makes both parties comfortable is something that has a lot of flexibility. I've seen other instances where, in more of that not AI specific focus deal perspective, right? Just going to share some data and you're concerned that the other party might do some things with it that you don't want, where you start asking questions, you start asking for ways to verify that they're meeting the restrictions, things like that, that have ultimately been deal killers. But at the very least, those fleshed out what was really on the table between the parties, which is not always what's in the four corners of the contract. And in those instances, the pointed questions, the diligence, and the trying to force guardrails and other types of protections fleshed out what was going to happen if they move forward, and then allowed my folks to do what I was describing a moment ago of making a practical decision about whether this was something they wanted to enter into. I think at the end of the day, what's in the contracts just set up things that you can sue each other for. They don't necessarily mean that that's what the other party is going to actually do. It's always good to flesh out what they're actually going to do and then proceed accordingly.
That's great, and goes into my next question too, of fleshing it out ahead of time in the contract. Should companies push for audit or oversight provisions in the contracts to investigate what the party's doing and if they are complying with the terms in the contract?
You have to. There's just no way around it. Trying to govern this stuff via filing lawsuits and doing it via discovery is not very viable, especially given the somewhat black box nature of how some of these solutions can work. But there's also a reality in what people can offer. A lot of companies that are using AI tools aren't necessarily hosting them themselves. So they are, to some degree, beholden to whatever rights they can get from the third party provider. If the tools that the counterparty is using aren't dedicated instances of it, they're shared ones. Practical in person, old school audit rights are something that you can push for, but the counterparty might not truly be able to give you. Over time, we'll see what happened in the privacy space and the data sharing and hosting space generally over the last 10 or 15 years. People get comfortable relying on the third party SOC 2 type 2 audit result as comfort that there were appropriate controls in place as it relates to data. I think we'll need some of those trust principles and the procedures behind those to evolve, to start covering these kinds of things, such that people can get comfortable relying on a SOC 2 Type 2 as it relates to AI as being a good verifier of compliance on the part of your counterparty. That's going to take some time. Absent anything else, when there's not been any kind of good viable audit, I've tended to fall back with just getting officer certifications and other similar periodic assurances from the other side that essentially establishes the basis for fraud in the inducement and fraud type claims and enhanced damages. In the event it turns out that they're just blatantly lying when they say that, nope, I'm definitely not training an AI model using your data, and then it turns out that they were. Not the greatest solution. Going back to the contract just sets up things that we can sue each other for. But at least this kind of bolsters that we could sue them for really bad things if it turned out that they were doing it. And sometimes that's the best you can do.
Well, that's great. It lays it out nicely for folks with good practical advice in terms of thinking about their data, how they're going to keep their data confidential and ways to use it, thinking about the model, realistic approaches and how the model is being used, and ways you can have oversight of the AI provider, AI partner as well. Any other final thoughts, Steve, that you might have for our listeners in terms of partnering with AI providers?
I think the one to really keep in mind is, especially as these products evolve, not so much the AI products themselves, but the value added solutions built on top of them. A good example of something that's a very du jour type use case for these types of models are things like predictive maintenance as it relates to complicated machinery. You see it in aviation, energy, where massive turbines and things like that are incredibly expensive. The maintenance and requirements are significant, and they have lots of very expensive parts that are moving really fast and can blow up if they don't get handled correctly. Time is incredibly costly. Some of the analytics available with modern tools have the promise of letting you know when something's going to fail in advance and giving you an opportunity to do preventative maintenance beyond the normal schedule. If people have seen 2001, there's the scene when Hal lets the crew know that a component's going to fail in advance and they should go change it. That's exactly the kinds of things that these platforms are trying to do. And if they do it well, there's a huge value in it. And the people that are offering these platforms know that. And so they're very expensive. It presents a very interesting dilemma from a contractual perspective and how you get assurances as the customer that you're getting the value that is represented by the fees that you're paying for the use of the thing. Because similar to the dilemma the crew in the movie had to deal with, how do you know whether it's what it's telling you is right unless you choose to not take its advice and see if in fact that component does fail, which if you do defeats the whole purpose of having the platform. This issue started to crop up several years ago when we were doing what people would call big data analytics on these types of platforms and weren't calling it AI. Same concept though. And from a transactional perspective, the notion of what would be an adequate assurance on the customer side is still evolving. There's a real tension between the fees that are being posed for some of these tools that if they actually did what they're being proposed is probably worth it. But it's hard to contract or to build contractual protections that give the customer assurance they're getting that value. There's a lot of room for negotiating and trying to craft protections in that space. Kind of the next layer of these interesting transactional legal issues that arise from these tools. We're all talking about how people can use data and whatnot. Those are mostly the inputs. It's once they start to actually deliver on the promises, and now we're paying for services that rely upon these tools. Now you got to figure out how to get guarantees that the outputs you're paying for actually what come out. And we're just starting to scratch the surface on that second part. It's very interesting, but it's hard to craft one that has really demonstrable remedies. We'll see how it evolves.
Well, there you have it, folks. Another interesting challenge to confront in the days and weeks to come. So thank you, Steve, for joining us today, and thank you for listening to the AI Council Code. We're so glad you joined us, and stay tuned for additional podcasts and more insights on AI legal issues.
Thank you for listening to this BakerBots podcast. BakerBots has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on BakerBots practices, please visit us at bakerbots.com. This presentation is provided by BakerBots LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.